Thank you so much for being with us here today. Would you please tell us your name and your role as well?
Sure, I'm Khylee Quince from Ngāpuhi Ngāti Porou, and I'm the Associate Head of School here at AUT, where I teach criminal law, youth justice, alternative dispute resolution, including restorative justice practice.
Great, thank you, Khylee. It's nice to be here with you. Just to get us started, how would you say that Indigenous communities have traditionally fared under the criminal justice system in New Zealand?
Not well is a nice short answer, but to flesh that out a little bit, Māori as Indigenous peoples of Aotearoa New Zealand have, initially upon initial European contact, we were left alone for a number of decades to continue to administer justice and address offending behaviours in the traditional way. So it's only really as the sort of long arm of the law stretched into Māori communities that Māori were part of what became New Zealand law, and our role there in relation to criminal justice has not been a happy one. So we have a very long pattern of overrepresentation as offenders, but also an overrepresentation as victims, and that pattern has worsened in the past 20 years. So now over half of all people convicted of offences in New Zealand at any given year are Māori or identify as Māori, and more than half of people in prison in New Zealand. And we're currently around 11,000 inmates. So for 15% of the population, that's a major overrepresentation.
Yeah, it certainly is. When we're thinking about how Indigenous communities have fared, and you mentioned that prior to the spread, I guess, of colonization within Aotearoa, that Māori essentially handled their own responses to wrongdoing or to harm. How does that make you think about what justice is? Like when you think of the word justice or the concept of justice, do you see them playing out differently in different contexts?
Well, that's a really interesting question. I don't think that most Indigenous people, Māori and other Indigenous peoples of settler states, I don't think they would ever see law and justice as being synonyms. That we see those two things as very different. We think of law, so one Māori scholar, feminist scholar, Ani Mikaere, talks about law being colonisation's enforcer. That's what we think of law generally. So law was used to change our relationship with our land, our relationship with our families, so it criminalised or changed the nature of our families so that nuclear families became the norm, so that different types of harmful behaviours were criminalised and different responses were used. Law was used to confiscate territory in the name of the coloniser. So we have quite a negative view, and law is a flashpoint for some of the most harmful practices of colonisation. So to think about that and the concept or process of justice as being similar things is quite problematic for us. We have a view of our own law and our own practices, but European or Pākehā law we don't see as being a vehicle to deliver justice, not easily. That's changed a little in the past generation, you might think, in relation to some of the sort of conciliation processes that have coalesced around law. So in New Zealand, treaty settlement. So we have obviously the Treaty of Waitangi, the sort of blueprint for colonialism and the welcoming of tauiwi or foreign people, starting with British colonisers. That document and the spirit and terms of that document have been used to prompt settlement processes in terms of the breaches of that promise and that covenant or protection over the intervening 150 years. So in that sense, the bringing of justice via law is a slightly new process, but one that we are taking on board, I suppose.
What would you say are the core concepts of the Māori worldview as they relate to justice?
So I think there's two things there, the Māori worldview and then as those concepts relate to justice, I think those are essentially the same thing. At the heart of the Māori worldview is relatedness. If I was to think about one core principle of Māori identity and Māori law and Māori justice, it would be relatedness. So we call that whakapapa, so literally the layering of relationships in terms of how related you are to papa, which is our term for the land, Earth Mother, Papa Tōnaku. And obviously that you can see then will come to some synergies with a relational view of justice. So our worldview is about, we think of ourselves as consocial people, which is that similar to the African idea of Ubuntu or other views of thinking about you are identified as a person through other people. I'm a person through other people. I'm a person through my connection to territory, to obligations, rights and responsibilities, to land, to people. So it's a very interconnected worldview, very similar to other Indigenous worldviews. So interconnectedness, and then therefore the core concepts of justice are around disruption of relationships, around disruption of obligations, responsibilities, either to the earth or to other persons. The egregiousness or seriousness of harm or wrongdoing is defined by the degree of relatedness. So the closer related we are, the more serious the harm. So again, that's similar to European or Pākehā concepts of duties or obligations, say, owed between parents and children, employers and employees. So people who have a close relationship, whether that's by blood relationship, employment or geographical closeness. But at a basic level, so for people who've never met before, that relationship is defined by humanity. You should not do this to another human being. You have obligations to the environment generally, but to your home environment, your home territory, you have a stronger obligation, and therefore the harm is classified or characterised as being more significant or serious. And then the penalty is therefore more serious. So our concept of deterrence and denunciation. So wrongdoing is defined by a disruption of relationship, a breach of restriction, and the process of dealing with that is the wrongdoing was probably again characterised by reputation. So we use the term mana, the concept of mana, authority or influence. So the idea is you have authority and influence around certain people, over your territory, and over people, places and things. And so a disruption or harm-doing, wrongdoing, damages that reputation. So other people think less well of you because of your inability to look after your own body, other people's bodies, or pay respect to other people's essential dignity. So all of those things that feeds into our idea of identity and reputation, I suppose. So it's a kind of a mashup of what in European law is both public and private law. So it's almost like a civil law concept that your reputation is damaged by your behaviour or inability to meet your obligations. So one significant difference, I think, between Māori and Pākehā criminal type of behaviour and wrongdoing is that most criminal behaviour in a Pākehā sense is around positive wrongdoing. So you've actually done something, you have taken something, you have assaulted someone. Ours is much more like what European law refers to as tort or civil law of obligations, and negligence or omission, failure to do something. We're much more about that because it's about a type of society that values. We're very outward looking, so you have positive obligations to do things rather than a freedom or a right to be separate and unengaged. We don't really buy that.
Mm. How might someone who has done harm to another person be dealt with in a Maori context? You mentioned severity of punishment, or penalty, I guess is the word you used, but what would that look like on a day-to-day basis?
So mostly we were in a pre-colonisation context and for the first few decades of colonisation, so in the non-urban context. People would live in communities of 100 to 200 people, so you're talking about a very community-level, community-based justice system and means of addressing harm and wrongdoing, which means that on a day-to-day basis, you're talking about a small community, so people have to get on. They have to live together. They have to move on from offending. So that then shapes the look of that system and the way that it works. So it is very one-to-one. There is no separate law enforcement system, there is no court, there is no judiciary, there is no policing, you are not summoned. So it's all based upon that idea that we have to live together, therefore we have to sort out any problems or wrongdoing. So the justice process of addressing wrongdoing is the same as any other form of dispute resolution in Māori society, whether you're talking about non-criminal harm or even just arguments between families. So it'd be dealt with, the marae is the forum, so that's our sort of, again, it's not a specialised institution in the way that courtrooms are in European culture. So it's an everyday, it's the place where all communal business is done. Births, deaths, marriages, dispute resolution. That's our sort of council chambers, if you like. So that's the venue. The fact that it is the place where we do all of our business shows you, I think, gives the sort of sociological message that justice is just part of everyday life. It's not, you don't use special language, you don't use special people, you don't go to a special building. It's just part of your everyday. It's normal. Disputes are normal, but also sorting out disputes is also normal. So there's no anxiety that is special to justice, which I think you find in some other communities or societies. So we think of wrongdoing as we do in our normal identity, if you like, as a collective issue. So even though the individual harm might be, I have hurt you as a person, we think of that as me and my family have hurt you and your family. So it's both collective identity leads to collective responsibility. So we think of wrongdoing as being between groups because we think of our identity as group-based. But in a practical sense, that's the reality in a small communal society also, because my wrongdoing against you as a victim, your experience as a victim will affect you being a wife, a mother, a partner, a worker, your depression, but you even not just your physical harm, but the way we'd call it your wairua, your spiritual balance will be upset by that, and it affects the people around you. That's common sense. So that's why you and your family will come to address that wrongdoing, because they will also want to voice what has happened to you. You know, this has meant that Khylee is now no longer functioning very well as a family member in our unit. You know, her work productivity is plummeted because of this. So we see those things as collective rather than individual harms. There's another advantage to that, in that often, there may be reasons why an individual person is not able to take agency or responsibility over what they've done, but other family members might because of reputation and mana. Our mana has been diminished, our reputation, our authority in this community has been diminished because this young person has done something that has, is ruining, has affected our family name. And therefore it's actually more important that older people take responsibility and say, yes, we have done wrong, and here is what we're willing to do to attempt to address that wrong and to move on from it. So it's a collective responsibility in a communal public space. So we believe and live very strongly by that mantra that justice must not only be done but must be seen to be done. So it needs to be open, it needs to be public, so that again, the ultimate aim of a Māori process of justice is to be able to say, kua ia, it is done. So it is satisfied. So that means you've actually really got the marrying of law and justice. Is everybody here satisfied? That's the ultimate end of a Māori dispute resolution process. And if everyone can say, and decision is made by consensus, which of course means it's non-adversarial, everyone gets to have a say. It doesn't mean that everybody's happy, that's not what consensus decision making is about, but everyone's had their say and they're satisfied. It's not to say they're happy, but it is done. We've dealt with it, you need to move on. That's really important. And there's a public declaration of that in a public space. That's really important. The collective nature of Māori dispute resolution also means that you're much more likely to get satisfaction in a collective group because people will want to move on. So an individual person might not be able to take, as I said, the agency around offending behaviour. They also might not have what, dispute resolution takes all sorts of capital, cultural, economic, social capital, to be able to say, I did something wrong, and I'd like to make amends for it, and I'd like to move on, and here's what I have to offer. Each of those things requires something either of a person's personality or maturity, of their economic capability to be able to say, here's how I'm going to make, what's the offer? What are you doing in terms of reparation or restoration? A young person is less likely to have that kind of capital in all of those senses. A poor person, an unemployed person is less likely to have capital. So it's like suing an insurance company. Collective groups, you're much more likely to get satisfaction because someone will step forward on behalf of the group to make amends. So it's from one group to another, it's that kind of process. That does then, if someone does, people often ask the question then, well, what happens if, say your wealthy uncle steps forward and makes amends on your behalf? That does set up an internal raru or conflict in the family. So but it moves it away from that public space to the private family space. Okay, we now as a family need to sort out how we're going to mend that bridge between the person who stepped forward here and that young person or the person that didn't, who will often be the individual wrongdoer.
Yeah, thinking about the incredible importance of the family and of the extended family, of course, makes me think about the 1980 reform around youth justice. And I'm wondering, particularly from a Maori perspective, why did that youth justice system need reform in the 1980s? What was going on then that required that change?
Good question. So in 1989, we had the Children, Young Person and Their Families Act, and that is a huge statute, and what it does is it essentially deals with two quite different processes or phenomena when young people come into contact with the law. And so one is a care and protection jurisdiction, so dealing with young people whose home lives require state intervention, so often around neglect or abuse. And it bifurcates or separates the state process of dealing with children and young people in that space and children or young people who are displaying offending behaviours. So the first answer to your question as to why was that reform necessary is because prior to 1989, our system dealt with those young people as an amorphous whole. So often, particularly in relation to institutional intervention, so children and young people would often be removed from families for either welfare-based or care-based need or for offending-based need, and they were usually housed together in residences that had both care and protection children and children who offended. That separation needed to occur, partly because of Māori criticisms around the welfare responses being a dragnet for very minor criminal offending. And this happened in other Western jurisdictions. So the idea that you'd have young people who were not attending school, for example, or engaging in minor shoplifting, minor theft-based behaviours, and being removed from their families and kept in institutions for years. A major overrepresentation of Māori children and young people for decades in the 20th century for that type of behaviour. So that was one reason. So a historical abuse of state care intervention and overuse of justice responses to essentially care and protection or welfare behaviours and problems in families. The other reason was the very clear push by Māori for more Māori responses. So this pattern of overrepresentation of Māori children and young people in our youth justice system had been going on for years, as it had in the adult system. So a push for reform around that. So claims of institutional racism. So in 1986, so the major push underpinning the 1989 reforms was the 1986 Department of Social Welfare inquiry into state practice. So that report, Puao Te Atatu, which literally means a new dawn is breaking. So we need a new response to deal with both Māori children in need of care and protection and Māori young people who are displaying offending behaviours. So that was major. Lots of other things going on, other pushes. Moana Jackson, one of the sort of godfathers, I suppose, of Māori criminology and legal scholarship, also did a major report published 30 years ago this year, so in 1988, which went around and really gave Māori voice to this dissatisfaction with current law and justice responses to Māori. Huge dissatisfaction with the police, with social welfare, so the institutions, law enforcement agents, sentencing options, over-imprisonment, so at every stage of criminal justice, from surveillance right through to courtroom practice, legal practice, corrections practice. So at every stage there was dissatisfaction from Māori in what was seen to be essentially an institutionally racist system. So a lot of, and added to that, of course, in the 1970s and 1980s, you had a movement away from non-adversarial systems of justice. So you had a growth of alternative dispute resolution, restorative justice practice, so different ways of dealing with offending behaviours. So it's kind of a coalescence of all these varying strands of what we would call whakapapa or genealogy came together to give us this quite remarkable reform, which is, the Children, Young Persons and Their Families Act. And in terms of justice, a family focus to, non-state dominated decision making for children and young people who offend.
Yeah. And going on from that, how would you say that restorative justice fits in with all of this and within the Maori worldview and concept of justice?
Well, it's very interesting in relation to the youth justice system is that in the couple of decades since the 1989 Act, people talk about the family group conferencing system, which is the core decision-making function of that statutory framework. They talk about it as if it is a restorative practice, but the language of restorative justice is not used in that statute. So you have a bit of a gap there, which is interesting. There are definitely synergies between restorative justice theory and practice and Māori justice theory and practice. As I've mentioned, a relational focus, so thinking about offending and justice processes as community issues and as issues beyond just an offender and an individual named victim. So that's important. The increased focus on victims' views, not rights necessarily, but the position of the victim as being more than just a complainant and a witness in a trial. So that the giving victim voice, giving victim a place at the table, there's a clear synergy there. Being more forward or future focused than retributive justice does in terms of looking at, what have you done in the past and how are you going to, atone or amend or repair that behaviour. Much more restorative practice and theory is obviously more focused on, again, future relationships and making sure that people are living harmoniously. All of those things show some synergy or commonality between Māori justice concepts and practices and restorative justice.
What needs to be restored? Thinking about that more deeply.
Good question. So this might be a point of divergence, and that comes down to essentially a Māori view of personality and personhood, in that we conceive of the human person, the tangata, as constituting the physical person, the tinana, also the spiritual person, so the wairua, and we think of offending behaviour as depleting a person's, or all of those aspects of the person, so the physical, the spiritual, and so we talk about justice processes as requiring whakahuki mauri, which literally means to raise the spirit, the life force of a person. But I do think that other non-Māori people they do have that concept of, you can think about it in terms of mental health, in terms of self-esteem. The way that you think about yourself changes when someone wrongs you, when someone commits a harm against you, even if there isn't a physical, bruise to show for it. It lessens your sense of security, of general well-being, and we call those two things wairua, spirituality, mauri, your life force, your joie de vivre, if you like, your joy for life, your, what you can give to living your best life, that's affected by wrongdoing. So that's what we think that's the point of the justice process, is to attempt to bring you back into the fold. So John Braithwaite, for example, Australian criminologist, talks about this idea of reintegrative shaming, that you deal with the wrongdoing, but you reintegrate the person back into the fold of whether it's the family, the community, whatever the social group is. So that's what we would think needs to be restored. So some similarity again to European or non-Māori ideas, but also some sort of culturally specific ideas of diminishment of spiritual and metaphysical, non-physical well-being is what needs to be achieved. Yeah.
What might be some of the Indigenous critiques of restorative justice?
So there are a number. So although we have these commonalities, some relate to that more sort of philosophical differences. So around, for example, the idea of how we define personhood, as I've just explained. So it might be that particularly that spiritual dimension doesn't tend to have a place in European law. Law is seen to be a secular thing. And we don't have any distinction between law and religion or law and spirituality. It's just life. We see law as rules, principles, and ethics of behaviours between human beings and between human beings and the environment and the spiritual world. We don't see any special. We're not anthropocentric. Human beings aren't any more important in that worldview. So some of the criticism, Indigenous criticism, Māori criticism specifically, will be around that, the lack of understanding and appreciation of the spiritual dimension to life. Some are more contemporary critiques around our position, not just in a cultural sense, our position in, say, New Zealand society, but in a more sort of economic sense. So the result of colonisation and the ongoing impacts of colonial, the colonial project, if you like, has put us in a very marginalised position in economic terms. So we have a disruption of that cultural identity. So many Māori, contemporary Māori people don't know about those traditional tikanga, law or kawa, protocols or practice of dealing with wrongdoing. They just live a marginalised, economically marginalised life. So the idea of, for one thing, I think the idea of restorative justice assumes that, to some extent, as does Māori justice, assumes civil society, functioning, healthy civil society, and civic participation and engagement. That you're assuming that this is a disruption from the norm. Well, for many contemporary Māori, it's not. Criminality, wrongdoing, harmful behaviour is normal. That is a terrible, terrible thing. So thinking about addressing this as abnormal behaviour, which underpins the idea that you are going to restore someone back to being a functional person as part of a functional family, and that this person is acting as a black sheep in an dysfunctional, abnormal way. That's the idea. That's the idea for restorative justice and for Māori justice. And the reality is that that's not often the case. So, in other words, you're dealing with how to deal with generally dysfunctional people with disrupted cultural identities and a lack of capital to be able to address wrongdoing is really, really difficult. So a core, I think, Indigenous critique of the past generation at least is that we are now such unequal citizens in this society that I think that most of those justice processes assume that we'll have something functional to go back to. And if that's not the case, it's very, very difficult. I've been in conferences where young people are thinking, and actually verbalise, you know, these terrible harms have been done to me and to my family and to the generations before them. Why am I here dealing with this little harm? Or I've stolen your car, sure, but why are we facing up to this little harm when these huge macro level intergenerational harms have been done to me, my tupuna, and our people? Like that, you know, that I can understand that anger and dissatisfaction with that. It seems to be, and it's private. You know, why are we dealing with this in a private setting when these huge public harms have been done in the name of the state against us? We don't get that. That's probably the core, you know, contemporary critique, is that it doesn't deal with macro level harms, and it's essentially private. So for all of the criticisms we might have about an adversarial justice system, particularly dealing with, you know, criminal harms, it's done in public. It's done in the name of the state, and it's done in public. So the patterns of overrepresentation, of over-victimisation, in New Zealand you would have to be blind not to see that the core business of our entry-level courts, the district court, the core business is essentially Māori. If you practice there, if you're engaged in justice in any way, the people coming in and out of the doors every single day of the week are Māori, as offenders, as victims. The judges are not, the police officers are not, the education officers are not. The people who are tasked with enforcing it, making it, you know, and essentially locking you up at the end of it, they don't look like us, but everybody else looks the same. And I think one of the benefits of that, although that is, we see that as a huge mamai, a harm and a pain, sorrow, the advantage of it is that it gives it a public face. Hopefully it gives it some public traction with law and policy makers. So one of the critiques might be that so long as restorative justice remains largely an adjunct process rather than a core public process, then essentially we might see it as sweeping us under the carpet. You are making this look like you depoliticise what we see as a very public political problem. You make this about that Māori boy facing up to the person whose car he's stolen, rather than thinking about that Māori boy, the fact his father's in prison, the fact all his uncles are in prison, the fact his grandparents have been in prison, the fact that they don't speak their own language, the fact that they've had their territory taken from them, he's never been to his marae, he doesn't know his language, his people, his culture. All of that's lost in this. It's a single encounter. It's like a single freeze frame still shot in a really long War and Peace saga. You know, it's like Lord of the Rings. You take one shot when it's actually, you know, this is a long trilogy here, and more drama and tragedy than comedy. You know, that's a core critique also.
Yeah, you know, restorative justice is often touted as perhaps a solution to some of these problems, or as something that can contribute to addressing these issues of overrepresentation, both, of course, in New Zealand as well as in the United States. How would you respond to that, I guess?
So I do think it is wrong or simplistic to view these processes as being diametrically opposed to one another or mutually exclusive, because it is undoubtedly, it's undoubtedly a better way of responding to harm, even amongst the people who have, you know, all of these other things going on in their lives and perhaps an inability to take individual agency over wrongdoing when faced up with a victim, etc. It's undoubtedly a step in the right direction because of those synergies between traditional practice and belief and just generally a better way of viewing wrongdoing in the community. So So I do think we need to acknowledge that and that there can be a role for restorative justice in attempting to transform the lives of people. So partly the languaging around the idea of rehabilitation, restoration, reconciliation, where I do think we can use those processes to assist with, attempting to assist people come to, functional well-being in conciliation between people. It still needs to be, the fact that all of these terrible things might have happened to you and your collective whānau, your extended family, your tribe, etc., and over a number of generations, that does not, it may explain, and I say this to clients or young people in particular that I speak to, that's not a barrier to you taking agency for your wrongdoing. It's an explanation, but it's not an excuse. So that's really significant. So it is a step towards doing that. You still need to make amends. It's not an excuse. It's not an excuse for failure to to own up to terrible behaviour. I do think we need to, and of course it can be used as a process, not just in that binary sense of Māori and the system, but as for members or parties within the system to attempt to reconcile their behaviour and practice and attitude amongst themselves as to how they're going to change the way they view other players in the system.
How might restorative justice better respond to the needs of Indigenous communities? Thinking about ways, you mentioned that it's a good step, or it's heading down the track of the path that we might need to follow. But what could be improved upon to better respond? So
I'm thinking my immediate response is use and then practice. In relation to use, so I think one of the things that has really characterised Indigenous experiences of both colonisation and justice, so I'm thinking around the other settler states of United States, Canada, New Zealand and Australia, is this concept of lateral violence. So lateral violence is where we internally harm ourselves actually more than we harm outsiders. And so it's a form of displacement, right? So that violence perpetuated in Indigenous communities tends to be perpetuated by other Indigenous people. So when we think of Māori men as the most overrepresented offender in New Zealand, well, their victims, their number one victim is other Māori men, and of course in the domestic context, their own Māori partners and children. So that lateral violence is a form of displacement against who we see as the original aggressor. It's a type of divide and rule, of course. So we've internalised these terrible behaviours and practices. You can use restorative justice to attempt to fix and address that. So to attempt to restore relationships between Māori people for the wrongdoing that we perpetuate amongst ourselves. Absolutely. That will require outside facilitation, no doubt about it. So the system response can be to facilitate that. There are other critiques around, for example, in family group conferencing practice around state domination. And by that I mean one of the, again, in theory, the family group conference and the statutory framework of the 1989 Act is an amazing recognition of collective identity. It refers to, I can't remember the number, I think it's 17, the number of times that whānau, hapu and iwi, Māori terms for family, extended family, sub-tribe, the full collective identity are used a number of times in a piece of legislation. That was world-breaking at the time. The problem was that Māori young people no longer live in whānau, hapu and iwi. Most of them couldn't tell you their tribes and sub-tribes. So it was really looking at almost a frozen anthropological identity at the time of colonisation. That Māori live in these extended families and they have all of these human resources to call upon, when the stark reality is that the most common conference is a young Māori boy and his mum. That's the modern marginalised identity. So again, you can use conferencing to attempt to, part of that idea is you must have a community of care. That's the social and cultural capital that's really important to be able to move on from offending behaviour. And if you've only got that very small family unit to engage in a family group conference, it's very confronting for them to be dominated by the state actors. So even if you consider the facilitator or coordinator, justice coordinator, to be a neutral person, they won't see that. The social worker, an education officer, a youth aid officer, you will often have 7 or 8 state players and a mum and her child. That's quite confronting. That makes it, very uneven, if you like. So that's something that needs to change. You may need to, for example, borrow from some more therapeutic practice. So I do think there needs to be borrowing from other justice approaches or practices. So the therapeutic practice, the team-based solution focus. I think there is part of it may be education. There is certainly an attitude that we are turning up. There's no assumption from Māori participants in conferencing that this is a democratic process. Not at all. I don't think they see it as any different from going to court. They're going to be there and they're going to be the recipients, the passive recipients of justice, in the same way as you might be in a courtroom where you say nothing, a lawyer speaks for you, a judge makes a declaration, and you leave and you ask your lawyer what just happened. Unfortunately, that has largely been the experience of many, many Māori people in conferencing practice too, that they don't feel, and you can see it, they are not actively engaged. But that is just a symptom of their real life, lack of civic engagement, lack of participation in society, lack of knowledge of how to navigate their way around what you might think of as quite inconsequential barriers in life. So that needs to change. So there needs to be some, again, facilitation around, assisting families to engage. That's a major thing. So I think coordinator practice, particularly or coordinator or facilitator practice in restorative justice, needs to actually be more hands-on. And I think, again, the dream of the 1980s, and it's a good one in theory, the dream of the 1980s and 1990s was that this is hands-off community justice, which is all very well if you have control over your own life and everyday life. But if you don't, you can't expect people, really, really marginalised people who have no control over their everyday life to be able to take control in a democratic sense in a conferencing process. That's just not going to happen. They're not used to it. It's not, so you actually need, I think you need, and I think one of the reasons for that, one of the positive reasons for taking that approach in the 1980s and 90s is to allow people to take control and have some self-determination. So it's really interesting in the New Zealand context. Māori would put that in the treaty framework and having regards to the Treaty of Waitangi. The 2 core articles of the treaty are Article 2, which gives Māori or affirms Māori self-determination, and we use the term tino rangatiratanga, absolute chieftainship. So that's allows and affirms your control of your own destiny. Article 3 was quite radical at the time in the colonial sort of whakapapa or history of settler states around the world. It gave Māori equal citizenship rights to all other citizens of New Zealand. That was really radical because most Indigenous peoples were not seen as being human beings even, let alone human beings with the same relative human worth as other, as the colonial peoples, the settler peoples. The issue of lack of civic engagement of Māori in ordinary everyday New Zealand life and our position in terms of, being at the sharp end of negative indicators around health, housing, education, life expectancy, you name it in New Zealand, is an Article 3 issue. It's a breach of that guarantee of equal citizenship status. In my view, and the view of others such as Juan Todi, Moana Jackson, Kim Workman and others, so Māori thinkers and practitioners, is that the idea of community justice and restorative justice is largely an Article 2 process, which means it's allowing for self-determination, but it's allowing for self-determination of people that have an Article 3 breach, really characterising their whole lives. So they live unequal lives and are expected to self-determine. That can't happen. So again, I think the theory in the 1980s and 90s was to not be paternalistic. Well, actually, we need paternalism, in my view, to enable us to bring, as the inequality indicators get further and further apart between Māori and non-Māori in this country. You need to bring those two things together before people are... You can't go self-determining until you've got basic equality. So that requires much more hands-on guidance. And that's quite an ask. I mean, I don't say that lightly, I don't say that flippantly, because why I say that's quite an ask is because, remember, all of that whakapapa, all of that genealogy or the underpinnings of those 1980s reforms were to get away from paternalism, the bad side of paternalism. The bad side of paternalism saw Māori children removed from their families. The bad side of paternalism saw Māori children abused in state institutions, saw judges give extremely racist responses to Māori as offenders, saw police give racist responses. So the 1989 legislation was attempted to address that. I actually think we need to go back to that idea of judges, lawyers, police being much more involved in determining their clients' participation and engagement in justice processes to ensure that they get equality, to ensure that they're not left worse off because it's been left to them. I mean, there's a great irony in that, and the idea, of course, is that you need to be able to, that has to be a temporary process, so to address inequality, to allow people to determine their own futures for themselves. At some stage, you've got to take the helping hand, if you like, away. But at this stage in our sort of society, I think that's what needs to be done. In terms of, I think the most obvious example, and I probably mentioned it in the when I came down to talk, of the borrowing of some of the best principles in practice has been the transition in youth justice to the rangatahi courts, which is a mashup of Māori justice, restorative justice and transformative justice. But it has particularly changed the role, particularly the role of the judge, but also the general relational ethic, I think, which isn't even part of, I don't think, how would you say it, of transformative justice per se. It's something particular to restorative justice that has been injected into this, and it's particularly around thinking about all of the actors as human beings. So, for example, although I've been to a number of the rangatahi court sites, but the one thing that they all do is that you're not the youth aid officer, you are Tom, and Tom has to introduce himself as a person by saying who is in his family. So everyone has to do their pepeha, and it is amazing. You don't get that in any other context. And quite often, as a lawyer, for example, in court, you'll go with your client, you'll see the judge. The first thing your client wants to know is what's the judge's name, and I'm thinking, shit, I don't know, because it's not part of the thing. They are there as the position, not as Mary, the judge, So that is something, that part of the relational aspect of RJ is crucial, and I think one of the key success components to the rangatahi court as a sort of reflective practice of moving on. And it's about establishing that community of care that's missing for those young people. And making the judge part of it. You're not neutral. Nobody's neutral. The cop's not neutral. The education officer, none of them are neutral. They have to be a person, and they have to be a person that brings themselves to the process. And that is a real mind shift for most of the people in the positions of power, the state actors, because they are used to, I am a person in uniform. This is my professional identity. We don't do that. We don't have a professional identity. You just have an identity. That's who you are, And it's amazing. It's amazing the difference it makes too, but particularly in terms of the consequences, the acceptance of young people, because it makes you a person. You're not just a cop. I can't just say that pig. I can't just say that judge. So particularly the use of pronouns changes. It's my judge. It's my youth aid officer. It's my social worker so and so. that it forces you to take agency because they become part of the community of care. That's huge, huge. You see judges give out their private phone numbers to these kids. You see, because it is a relationship, they become, and I also think it makes them think more. Think more carefully about the bigger context things, because you think about them like you think about a friend. What sort of home is your friend living in? What are they going to? It's non-transactional. I think that's fundamental. That's something that will be huge to change on a bigger scale outside of just the rangatahi courts. But I really think that's the key success factor. Everybody is coming as a team, but as a team of actual human beings, not roles, not undefined, unnamed people. Yeah. Good question. And again, because we don't silo off justice from life generally, the big issue is addressing inequality. Addressing disrupted cultural identity, which we'd all put in that Article 3 basket. How do we make ourselves better, more functional human beings? That then will, the obvious logic would be then that should have an effect on offending behaviours, and therefore there should hopefully be less need for justice. But remember, we also think about justice in quite a normal, we assume that there will be wrongdoing and that there will be, we do have we have a clear normative idea of peaceful relationships between people. But we also accept that those things will be disrupted. But underpinning that is that you have something to get back to, that you have a normative idea of well-being, that you have a normative idea of functional family. So it's those things. Once we fix those things, so I think our future in criminal justice is not to think of criminal justice as a separate thing. And I think we've seen a clear movement towards that in, at the core of the 1989 Act was that separation of care and protection, welfare and justice. All of the judges know that the kids are the same kids, the families are the same families, and so they've had to pretend, here's my family court judge hat, and now I'm wearing my youth court judge hat. And the same young person saying, you've known me, and I've seen this, you've known me since I was removed. You are my family court judge. You've been here since I was removed from my family at aged 4. Here I am as a 15-year-old offender. I'm the same person. You're the same person too. This doesn't make sense. Some judges are very good at articulating that, I'm here to deal with you in this matter, but of course I know who you are, and because that gives this false sense of, that makes it look like a transaction. We are here today for, a follow-up to your youth justice conference, knowing that you've got this care and protection conference and background history. So I think we've collapsed that, and I think that's appropriate. So I think our major direction is whānau order across the board. Family, well-being, wraparound social services, so that it's not just seen as either a care and protection welfare matter or a justice matter. I also think there is a very strong movement towards promoting better whānau engagement, no matter what the context. So again, it's promoting that civic engagement responsibility to enable people to sort of self-determine. Again, that's come through quite clear in the Oranga Tamariki provisions and the new legislation, and having better cooperation between the agencies about how they do that. So for example, I was telling you I was writing those cultural reports in, they're all criminal jurisdiction, of course, under the sentencing legislation. Similar process applies in family court for care and protection. In the past 3 years, they've done 3. 66% of kids in care in New Zealand are Māori. 3 of them have had reports about their being Māori, which is insane. Bringing those two things together to say, okay, you need to, what is the context of these kids' lives? So there's, and again, I think that's partly because of not sharing practice, not sharing, okay, this is taking off as a phenomenon in sentencing, thinking about people's cultural context in which they offend. We need to do that more in care and protection. I actually think the terrible fact of that, and again comes down to what I mentioned about the privatisation of restorative practice, is that the fact that that most offenders in the district court every day are Māori, the fact that most of them are victims, the fact that the judges aren't Māori is so normal. It's just the elephant in the room. Nobody even bothers to think about it. And I've had judges, as I've heard practitioners, ask for funding to get a cultural report. Why? This kid's Māori, but every other kid on the docket's Māori too. So do you want reports for all of them? To which my answer is yes you do. Because we actually should think about them all as not this amorphous bunch of brown offenders, but as people who, there are clear patterns, but I actually think that's part of it, that it's become so accepted and normalised that we are the offenders in this country. I think I told you, I wrote this book chapter on Māori and criminal justice a few years ago, and I started with, that old classic, what do you call a Māori in a suit? The defendant. And the publisher said, you can't, that's racist. I said, but it's true. And I said, I know, and I have insider privilege because I'm Māori, like I can say that stuff. And I fought them for months, and I thought, well, it's true. It's a fact of life. Why do you not want to say it? It's, so that normalisation, that's insidious.
I like hearing the way that you're reflecting on it and talking about it, and I've not thought about it as an Article 3 issue, because of course coming from America we don't have a treaty, but I've often thought
we have equal protection under the Constitution.
Yeah, there's certainly other legislation that would be useful to think about in that manner, and people are, but I often think about restorative justice as there being room for more support. As a practitioner, as a facilitator, starting to see cases that just look really similar, or starting to feel like this is the smallest thing in this person's life. It's about to be one of the bigger things because we've now intervened in a justice setting. But what we really need to be looking at is why you're in this office.
And not wasting the information that you are bound to get. So again, that's partly that having to reconcile like a history of paternalism, surveillance, and unnecessary intervention. But if someone shares with you, information that will be, useful, in a whānau ora type sense, for example, so I stole this because, feeding family, whatever. What do you do with that? So just the system being more responsive to solving, that's taking the problem-solving approach, right? And saying, okay, well, that's something we need to park over here for the education officer, or, there are things that have grown around that. But I think there are other things so that, this doesn't just become another encounter with, authority.
Right. Well, and I do quite strongly believe that when restorative justice is done well, that's exactly the issue that it's going to be addressing, are those underlying needs and causes and problems. Like, those are the harms that we're going to look at within that, even that individual process. The struggle that I've encountered is the resourcing to actually do that. What are we going to do about the homelessness we're encountering when obviously there's criminal offending coming out of a need to eat? And wanting to, there being a genuine desire on part of all the participants to address that issue, but then not knowing where to go next. Exactly. So that thinking about it through as this Article 3, well, we have to look at fixing all of these bigger inequality issues and poverty issues and marginalization problems in order to then be able to repair the harm that's been.
The other thing is, that voice is so important, of people actually know that those are really big issues, but they still want to be able to articulate what's going on. So it's also the passivity of ordinary court is it's just horrific. It's people can't be bothered because there's no listening for it. So I think that's one of, again, the core aspects of restorative practice that is a positive, is that there is a listening for, you know, what we would call further and better particulars, you know, of a wider range of information. When you go to court, you know you're only talking about the thing that you did on that day to that person. Everyone knows that, and there's these choices of outcomes. So the expansion of you know, possibilities is, you know, as a response, but also even just the expansion of, you know, actually this person might listen to, you know, and that deals with some of that sort of oppositional defiance type behaviour or lack of engagement or anger, and, you know, so talking with people that are trained in those kinds of you know, conversations is really, really important, you know. Yeah, so no, there are lots of good things that can, yeah, then there's the question, what do you do with it? Yeah, what next? And how you can respond to them, you know, on the spot. Yeah. The how to repair the harm can be the challenging part. Yeah.
If you could quickly define or describe the rangatahi courts.
Sure.
And how they would fit within the restorative array of offerings.
Sure. So rangatahi courts is what's called a judge-led initiative, by which we can say then that it's a non-legislative change to youth court practice in New Zealand. So the 1989 Act established the youth court. So the youth court is a division of the district court. So it deals with young people who offend aged between 14 and 16. So it's beneath adult jurisdiction, and it has this largely, you know, restorative approach to dealing with young people offending behaviours for everything other than murder and manslaughter, which is automatically transferred to adult jurisdiction. That court generally looks much like a district court. So there is a district court judge with a youth court warrant who usually has pretty good skills in dealing with young people, and but it is in a courtroom. They don't robe, so they look less formal. The atmosphere of the youth court is again much more relaxed compared to a district court. The rangatahi court, so rangatahi is one of the terms we use in Māori for young person, so it is a Māori-led initiative. So 10 years ago this year actually, so Judge Hemi Taumonu, who is a district court judge with a youth court warrant, went to the then chief judge of the youth court and asked for permission to establish a monitoring court that deals with largely Māori young people. So much like an adult jurisdiction, more than half of young people coming to the attention of the court are Māori. And so he wanted to try something new. So the rangatahi court moves and so there's no change to the statutory framework. They move the venue of the court to the marae. So the marae is again the sort of centre piece of a Māori community in terms of a physical space. And moving from a court to the marae is really, really significant because it puts it on our territory and our space. So many Māori talk about the marae as the last bastion of private Māori space in New Zealand. It's the one place that the Crown cannot take away from us, they cannot interfere with. So inviting essentially the Ministry of Justice into that space is a really big thing. And that, in my view, is evidence of the partnership, you know, the treaty partnership between the Crown and Māori. So Māori communities host this monitoring court. So it's called a monitoring court because in the youth court we have, you know, the core decision making is done by families and family group conferences. Then they come up with a plan. The plan is monitored by the youth court. So the court has a very hands-off approach to you know, being involved in youth offending matters. The rangatahi court replaces the youth court's monitoring function. So a Māori family will come up with a plan. That plan will be monitored on the marae by a judge. Most of the judges that are rangatahi court judges are Māori. There is use of Māori language, Māori law, Māori custom and practice in the way that they host this monitoring function. There are a panel of elders. Each court does it slightly differently. There are currently 16. There'll be another one open next month in February. So rangatahi courts perform the monitoring function, but their core business, I suppose, is to recognise the cultural identity of the young people whose plans are being monitored, and to assist them with repairing their, what is often a disrupted cultural identity, and forming a community of care around that young person. So it's a much more hands-on approach to making sure that the plan doesn't fall over, that the plan doesn't fail, and that after the plan has been discharged, that the young person will still have these supportive people in a marae community that are there for them in their educational, social, cultural need. So it's a very future-looking process.
Oh, thank you so much, Khylee. It's been a real pleasure to get to talk with you today, and I know I've got a lot to think about, and you've offered quite a lot to us to contribute to our understandings of how restorative justice fits and works and doesn't work for Maori today. So thank you again.
Kia ora. Thank you. Really bringing together law and justice is really, like I was at a conference last week, which was about Pacific. It was a focus on Samoa, but it was about Pacific custom law and constitutionalism. It's about bringing custom law into contemporary sort of democracy. But as soon as I saw the program, I laughed out loud because, it had those sort of breakout sessions like you have in conferences. One was on law and one was on justice. I was like, you couldn't get more obvious than that. Justice has got nothing to do with the law. You go sit over there, lawyers, and people that actually want to fix shit, go over there. I thought it was hilarious. And I was like, right, so all the sociologists and criminologists were in one corner and the lawyers and politicians were in the other. This is the rules and this is how we should behave. Two different things. It was fascinating.